Hello and welcome to this series of talks on employment injunctions. I'm going to review some cases that happened in 2015 and by doing that look at some of the principles involved. I think these talks will be of more use to the practicing lawyer, but they may assist people who are having to conduct their own litigation who are involved in these sorts of cases. We're going to be looking at cases involving restrictive covenants, use of confidential data, and other typical areas that come up. These are not offered as legal advice. If you need legal advice, you should seek it from a lawyer, whether that's a solicitor, or you can apply directly to consult with a barrister under the public access scheme. My name's Declan O'Dempsey. I'm a barrister at Cloisters Chambers. I've spoken previously about the nature of injunctions, but I'd like to recap on some of the basics as they affect interim, as they're called, injunctions. You'll need to have a look at the civil procedure rules. You'll see there that an interim injunction can be granted at any time during the proceedings themselves, or indeed before a claim is issued. The procedure itself is set out in Civil Procedure Rules 23. One of the phrases that you will hear from time to time is a reference to the American cyanamide principles. This was a case and it set down guidelines for judges in relation to interim injunctions. Just a few words about interim or interlocutory injunctions. A defendant or the respondent to an application can be sent to prison for breach of an order. When an application is made for an interim order, it sometimes happens that it's not possible to make an order without some injustice to one side or the other. So it's important to remember that this is the context in which the judge is going to be looking at whether or not to grant an interim injunction. Secondly, it's important to remember that a claimant is entitled to an order just because it's sought. The claimant has to prove at least something. So what does the claimant have to prove? Generally speaking, after the American cyanamide case, if an application is made for an interim injunction, then the court has a discretion whether or not to grant an injunction. Injunctions are always discretionary. Now, having said that, the exercise of the court's discretion is guided by these principles. Generally speaking, the court will look to see whether there is what they call a serious question to be tried. Now, that doesn't mean that any old point that's brought before the court will be treated as a serious question. It's going to be an objective judgment made by the court. Does the court think that there's objectively a serious question to be tried? And the claimant has to show that there's a real prospect, rather than a fanciful one, of success. And if you're a litigant in person, it can be quite difficult to achieve the kind of perspective that you need to achieve, the objectivity you need to achieve, in order to be able to ask yourself whether you've got a real, as opposed to a wishful thinking type prospect of success. Nevertheless, that's the standard that the court will be applying. And if the court concludes that there's a serious question to be tried, then two other questions arise. These are, would damages be an adequate remedy for the party injured either by the granting of the injunction or because the injunction wasn't granted? If damages wouldn't be an adequate remedy, then where does the balance of convenience lie? If you can get over that quite low threshold, in most cases, then the court moves on to those other questions, the adequacy of damages. So you need to give some thought to how that issue is going to be addressed. It's important to note that these sorts of interim injunctions are temporary and discretionary. The court knows that it's using untested and incomplete evidence given in written form, and so therefore it's not going to be in a position to determine conflict of evidence. It won't want to decide difficult points of law using this procedure. Uncertainty in itself, however, does not stop the court from granting an injunction. So the mere fact that some of the facts are uncertain won't necessarily stand in the way. If you're seeking an interim injunction, it's important to remember to put in or give an undertaking that if the injunction on an interim basis is granted and then it turns out that it shouldn't have been granted, that you will compensate the other side and are able to compensate the other side for any damage that they suffer as a result of what turns out to have been the wrongful grant of the injunction that you're seeking. The interim injunction is aimed at protecting parties only where damages are an inadequate compensation for the wrong done. And the question of the balance of convenience, the need of the claimant is weighed against that of the defendant. And it may be that there will be inconvenience on both sides, but the court will consider whether or not the balance swings decisively in favour of one rather than the other. So what does the principle that a serious issue needs to be shown mean? Well, the House of Lords, in setting down the test, remarked it's sufficient if the court asks itself if the actions of the person applying for the injunction are not frivolous or vexatious, or in other words, is there a serious question to be tried? This could be put another way: is there a real prospect that the claimant, the applicant, will succeed in the claim for a permanent injunction at the trial? I want to turn then to Sarker and Worcestershire Acute Hospitals NHS Trust. This was an application for an injunction to restrain disciplinary hearings concerning gross misconduct against a doctor. The doctor had been identified as dyslexic and sought adjustments to the disciplinary process. These included the need for the hearing to be adjourned. He said he hadn't had time to prepare. He had been given 12 days to prepare for the hearing and to get through a substantial amount of information. So the court considered whether to grant an interim injunction to force the adjournment that he had been denied. In the case of a normal injunction, an interim injunction, the court does not ask whether the claimant is more likely than not to succeed at trial. That process can lead to mini trials occurring on the evidence, and that's not the intention of this procedure. But the court does ask, as we've seen, whether the applicant raises a serious question to be tried. They then go on to look at whether damages would be an adequate remedy for the claimant if he was to succeed at trial, and if they wouldn't, could the defendant be adequately compensated by the claimant's undertaking as to damages if the defendant should succeed at trial. If money couldn't adequately compensate either of them, then the court has to consider where the balance of convenience lies. And that essentially means what disturbs the status quo at least, and the status quo is generally regarded as the last step that's been taken. However, there's an exception to the principle of simply showing a serious issue to be tried. If the interim injunction will in fact dispose entirely of the real difference between the two parties, so that there won't be anything practically left to go to trial, then you don't use that standard. You do look at the strengths and weaknesses of the case in that situation, in the sense of trying to determine whether or not the applicant will succeed at trial. Now, in the employment context, this often has applied to restrictive covenant cases. However, as we'll see later on, this principle is starting to break down because of the availability of swift trials. So just reflecting on that point in the case of Sarker, if the only question was whether a serious issue was to be tried at the full trial, then that would be quite a low threshold. However, in the case of Sarker, granting the injunction effectively means granting the adjournment. And in those circumstances, some assessment of the claimant's prospects of success over and above the modest threshold needs to be made. As against that background, the court considered the previous case law in this area. The cases had warned that you should be careful about using injunctions to micromanage disciplinary proceedings, that it was desirable to allow such proceedings to take their course as the procedure envisaged by the parties' contract. However, it's not a universal rule, and if you can identify that there is a clear wrong taking place requiring court intervention, then the court will be prepared to intervene. Now, this means something extreme has happened in the process, or that some fundamental right has not been observed. But in the absence of a clear wrong, the court may well view an injunction at this point as micromanagement of contractual discretions given to the employer effectively by agreement between the parties, and they won't intervene in those circumstances. The next case I'd like to look at is the case of Al-Mishlab and Milton Keynes Hospital NHS Foundation Trust. This was an attempt to obtain a declaration as to rights, namely in this case that it was a breach of the contract that the doctor was excluded from his employment, and also he sought an injunction requiring the trust to permit him to return to clinical practice. The starting point for any question of whether there's been a breach of the contract is to ascertain what the contract means. In Al-Mishlab, the court considered whether to make the declaration and injunction, and against that background considered the maintaining high professional standards policy. Now, this policy was found to be incorporated in the contract, and its provisions were said to have contractual force. The provisions dealt in part with exclusions to practice. What's interesting about the case is the fact that the court was prepared to look at the purpose behind the policy which it found was incorporated. Here, the purpose of the policy, effectively of suspension, was to combat a perceived suspension culture in which doctors charged with incompetence were too readily being suspended pending the outcome of investigations. This meant that they remained suspended for long periods of time, and this was detrimental to their own well-being and the professional development, and disadvantage also to the NHS itself. So there was a clear purpose behind the policy. The court therefore looked at the correct interpretation of the contract in the light of that purpose, and said that it was important to bear in mind that in an employment procedure such as this, maintaining high professional standards in modern NHS, the employer is not engaging in a judgmental, i.e. an adjudicative process. It's not like a system of justice, but the court has to remember that what the policy is doing is managing the business and the employees. So it was right to consider the policy behind the contractual provision, here the speed of resolution of a suspension. The question of which parts of a policy are contractual and which are statements which are merely encouraging or exhortatory, which don't require the parties to act in a certain way, may be a difficult question to answer, but it's necessary to look at the procedure and decide which provisions are contractual as opposed to just the expression of the hopes of the parties. Now, in doing that, previous case law assists. The case of Hussain, another NHS Trust's case, suggested that what one should do is to look at the importance of the provision to the contractual relationship as a whole. So, for example, to what extent does it touch on matters of trust and confidence? That may be an indicator of it having some contractual value, but this is merely a factor. How detailed is the provision? The more detailed it is, and the more prescriptive of conduct it is, then the more likely it is to express the contractual intention of the parties. How detailed leads on to the next point. How certain are its requirements? Any promise or idea will be incapable of forming part of a contract if it's too vague to form a contractual obligation. But you also look at things like the context in which the provision is set. Is the provision set in the context of other provisions which are contractual, or are the other provisions amongst which it sits for guidance only? You need also to look at whether, if the term was given contractual effect, it would be unworkable. Clearly, if it was going to be unworkable, it's highly unlikely that the parties intended that it would be a contractual term. You do have to look at the language of the provision, but the distinction between being mere policy and being contractually valid is not simply the distinction between sentences which say that the parties should do X, Y, and Z, or sentences which say the parties must do X, Y, and Z. Either of those could occur in a policy, and either of them could occur in a contract. The court also in Al-Mishlab identified two types of discretion for which it was going to be necessary to give some thought. Even if a contract appears to confer an unfettered discretion, so in other words, a discretion which has no limits on it whatsoever, the discretion is in fact limited because it mustn't be exercised capriciously or unreasonably. You'll only be able to show a breach of contract on this basis, that a discretion's been exercised unreasonably, if the exercise of the discretion falls outside the range of reasonable responses. So that means that the court will look at whether the employer, or a reasonable employer effectively, could reach the decision which the employer actually did. And if that's the case, it's unlikely that there'll be a breach of contract in those circumstances. Another type of discretion is, as it were, a conditional discretion. So if a discretion only arises if certain conditions are satisfied, then obviously the court has to decide whether the conditions were met. Now, for our purposes, the facts of the case are not that important. The claim itself was dismissed on the facts, and it was found that there was no breach of the policy at all. I mentioned earlier that the serious issue to be tried test is not used where the application for the interim injunction is likely to dispose of the issue between the parties, so that in practical terms there's nothing left to go to full trial. If the injunction's granted, the claimant gets everything they want. If it's not granted, the defendant gets everything they want in practice. So in those sorts of cases, the House of Lords has indicated that if the application will dispose of the case, the degree of likelihood that the claimant would have succeeded in establishing his right to an injunction if the case had gone to a full hearing is a factor which should be brought into the balance by the judge in weighing the risks that an injustice may result from deciding the application one way rather than the other. However, even in these cases, what is called for is not a trial of the action. It is up to the judge to control the amount of inquiry that is going to take place into the respective merits of the different sides' positions. But the question of whether an application for an interim injunction is likely to dispose of the whole case often turns on the question of whether or not there can be a quick trial. And it's only if the claim can't be tried before the period, for example, of a restrictive covenant has expired or has run a large part of its course, that in those cases the grant of an interlocutory injunction should be regarded as effectively disposing of the case. The defendant should, in these sorts of cases, consider seriously offering an appropriate undertaking until the hearing of the case on the basis that a speedy trial is sought by both parties, and always, of course, provided that the claimant can pay damages on a cross undertaking in damages. But if a speedy trial is not possible, then it may be necessary to have some kind of contest on the interlocutory, on the interim application. So judgment was handed down in another case on the 2nd of February 2015 in the case of Le Puy Limited and Potter and another. There was an issue as to whether the defendant had signed an alleged agreement, but also, if he did, whether the company had breached the agreement in such a way that he would, in any event, have been effectively released from any restrictive covenants in the alleged agreement. And it's an interesting case because the employees' representative argued that the court shouldn't apply the ordinary threshold test for the grant of an interim injunction, the American cyanamide test. In other words, shouldn't apply the test of whether there was a serious question or issue to be tried. But it was argued instead that the court should reject the application for an injunction unless satisfied that it was more likely than not that the company would succeed at trial. The practical nature of the court's approach can be seen because it would only be if you can't hold the trial before the period for which the claimant claims to be entitled to an injunction has expired or substantially expired, that justice requires that further consideration of the merits of the case. But if a trial can come on within the restrictive covenant period, so that a substantial period of that covenant is left, then the question for the court is not, is there merit such that the claim would probably succeed at trial. The question is there a serious issue to be tried? The amount of time left in the covenant by the time trial would come on is going to be a question to consider in relation to where the balance of convenience lies. So in other words, if the trial can be expedited, the test to be applied may be different, and so it's important to have an idea of how quickly the trial could come to a full hearing. So it may be worth trying to get in touch with the listing officers. The tests to be applied then are, in the context of whether there's a serious issue to be tried, is the evidence not so obviously incredible that it can be rejected at this interim stage? It's important to remember that even if there are inconsistencies within evidence, it may still establish a sufficiently good arguable case to satisfy this lower American cyanamide threshold test of a serious issue to be tried, unless disclosure takes place, and until disclosure takes place and the witnesses are all cross-examined, is it the sort of case where it's simply not possible for the court to form any concluded view as to where the truth on issues may lie? May there be an explanation for any inconsistencies? For example, the fallibility of human memory. It's not unknown for wholly honest witnesses to give evidence inconsistent with other honest witnesses, or even parts of their own memory, their own testimony. Is there material, even in the evidence which is before the court on the application, which might be used to test the applicant's own credibility? These are important questions because it's generally wrong at the interim stage for the court to speculate on how the trial may go. So, for example, suppose somebody says that a document is forged, the judge is highly unlikely to put themselves in the shoes of a handwriting expert at the interim stage. So will an inconsistency that you may be quite keen on in fact require expert evidence? Handwriting might be that sort of case if you think that a document has been forged. Unless it's so immediately obvious so as to permit a non-expert in the examination of questioned documents, for example, to form a useful view one way or the other, the court won't determine it. In the American cyanamide guidance, it was said it's no part of the court's function at the interim stage of the case to try and resolve conflicts of evidence on witness statements or affidavits as to facts on which the claims of either party may ultimately depend, and it is also not part of the court's role at this stage to decide difficult questions of law which call for detailed argument and mature considerations. Those should be dealt with at trial. So if your case depends on those sorts of matters, then it is unlikely that you will be able to require the court to see things from your point of view. In other words, interim injunctions are probably a more blunt instrument than many litigants would hope for. In the Puy case, the court decided that the only covenants which the company was asking the court to enforce were expressed to last for 12 months from the termination of employment. And looking at that, they would expire in mid-November 2015, and it was common ground that there could and should be a speedy trial of the issues relating to liability in April 2015, so that there would be a judgment in April or May 2015, leaving about 5 or 6 months of the 12-month covenant to run. So the court decided that the approach in American cyanamide could be applied. In other words, the test was whether a serious issue was to be tried, because the application wouldn't in effect dispose of the action finally. and the covenants, by the time of trial, will not have substantially expired. So that made a big difference to the test which was to be applied in that case. The case is also useful if you're considering the practical approach you need to take to presenting evidence if you're claiming the enforcement of a restrictive covenant, say as a business. It's not enough simply to assert that there's been business interest that the restrictive covenant protects. You should be prepared to give evidence of that interest, and you also need to make out a sufficient case that the covenants are no wider than was at the time of the contract being entered into, no wider than was thought reasonably necessary to protect that proprietary interest that you assert. So in other words, it doesn't matter whether an interest has developed since the contract of employment was entered into. If at the time of the contract the company didn't have the proprietary interest in question, then it will not be able to enforce the restrictive covenant. However, most of the things that restrictive covenants protect are legitimate business interests and the court. But the starting point with restrictive covenants is that in principle a covenant in restraint of trade is unenforceable, and it's only going to be enforceable if it's reasonable with reference to the interests of the parties, yes, but also the interests of the public. And unless the unreasonable part can be severed by the removal of either part or the whole of the covenant in question, its inclusion renders the covenant or the entire contract, as appropriate, unenforceable as a matter of public policy. So in Le Puy they looked at whether the covenants were reasonable with reference to the interests of the parties concerned and the public. Post-termination contracts generally are regarded as enforceable if they're reasonable, and you may get them in business deals. Say if somebody sells a business and goes to work for the buyer. Covenants in employment contracts on their own are viewed more jealously than those sorts of commercial types of contract. And the employer has to show that the restraint is reasonable and in the interests of the parties, and in particular that it's designed for the protection of the proprietary interest of the employer and that the restraint is reasonably necessary for that. Now in the next talk we'll start looking at some of the cases dealing with the protection of confidential information and some of the new methods or developing methods that are being used regarding the use of databases.